On September 27, 2024, police pulled over Mr. Kendrick Wayne Dailey after spotting a fake license plate on his car that read Traveler. The traffic stop quickly escalated, prompting the police officer to arrest Mr. Dailey on the spot for interfering with the public duties and authority granted to him by law. Following this, Mr. Dailey was issued an unsecured $100 bond and later appeared for his probable cause hearing on October 4th, 2024.
You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Officers initiated a traffic stop in Harris County, Texas for a vehicle having a fictitious plate bearing the word Traveler on it. During the stop, the defendant refused to provide identification or insurance information, stating, "I do not consent to any of this." Officers attempted to remove the defendant from the vehicle, and the defendant actively resisted until he was detained.
That's very conclusory. What did you say?
Actively resisted.
Okay, I need more than that.
This preliminary proceeding's sole purpose was to determine whether there was probable cause or a reasonable basis to believe that Mr. Dailey had committed a crime. Judges typically rely on the probable cause affidavit or the statement read by the prosecutor as the foundation for deciding whether the case should move forward. In this hearing, however, Judge Fleischer noted that certain descriptions in the affidavit, such as the claim that Mr. Dailey actively resisted, were too conclusory and required additional factual detail to establish that the defendant had actually given reason to believe he resisted. As a result, the judge nearly found no probable cause until the prosecutor cited supporting details elsewhere in the report.
I reviewed the body cam this morning from the officer who initiated the traffic stop. The defendant.
No. You can't do that. No. It has to be in the report. In the DIMS, he has to say more than just a conclusory statement about what happened.
In the DIMS, it states that the officer attempted to pull the defendant out of the vehicle with him actively resisting and pulling away from the officer and other deputies. And the defendant continued by turtling his arms as they got him to the ground.
All right. Better. But
Yes, sir.
you telling me that he actively, it's a conclusory statement and we need more, right? It's like saying, okay, he was speeding. Really? How fast?
Yes, Judge.
So that's why conclusory statements don't fly, but that's enough.
With no rebuttal from the defendant and body cam footage supporting the officer's version of events, Judge Fleischer found that probable cause clearly existed. So the next step for Judge Fleischer was to set specific bond conditions that the defendant would need to follow while the case proceeded. Otherwise, Mr. Dailey's bond could be revoked, which would cause him to be taken into custody until further proceedings.
Do you have liability insurance in your name?
That's right.
And you can't drive. Once you get insurance, I will happily allow you to drive. It's all I'm doing is trying to protect the public and trying to protect you in the event that you get into an accident. They don't care whether you're traveling, whether you're whatever, however you want to term it. If you get into an accident, they're going to come after you. They're going to sue you, try to take you for everything you got. And that's why for $50 a month, you pay for someone to represent you in the event that you do get an accident. And depending on how much you pay, you're covered $50,000, $150,000. So all I'm asking you to do is follow the law. I'm not going to put any other conditions on you. No drugs, no alcohol. I don't know. All I want you to do is get insurance. If you can do that, I'll allow you to drive. So the only condition now is just don't drive until you get insurance. Once you get insurance, show it to me. I'll take your no driving restriction off and then do whatever you want. You need a lawyer to represent you there.
Initially, the only bond condition set was that Mr. Dailey should obtain valid liability insurance before driving again. Yet a little over a month later, the court modified the bond, adding a condition forbidding the defendant from remaining unemployed. While this may seem unrelated to the case, the court likely viewed this condition as connected to the defendant's ability to maintain the liability insurance he is required to carry. And as we'll see in the second case later, there's a recurring theme among sovereign citizens that chronic unemployment often contributes to their inability to comply with the justice system.
So what are you doing these days?
Right now?
Do you work? No? Okay, why not? What were you doing?
Truck driver.
That's a great job. Don't you make a ton of money truck driving? Why would you quit?
Making money from my check.
Oh, I see. Child support?
No.
What?
They said they overpaid me and they never, they was taking $170 out of my check for no reason. They never gave me anything to sign.
Isn't there a place that you can go to dispute that?
I have no clue. You tell me.
HR. Go to HR, go, hey man, this is why my check should be what it is. If they rightfully underpaid you, then they should, give you what you rightfully are owed. If they did overpay you, that's equally not fair though, right? So what's good for the goose, good for the gander. So if you quit just in spite.
I was really I had 2 weeks notice in. I was gonna quit before because I was going to another
So
job.
you need someone to represent you, right? We'll give you time for you to get a lawyer. We'll give you a month, but when you come back, you need a lawyer to represent you. Okay, so Mr. Dailey, what now? I'm going to have you just sign this promise to us that you're not going to drive until you get liability insurance. So get it, bring it back to me, show me that you have insurance with your name on it, and then I'll take this off.
After the initial hearing, Mr. Dailey missed 2 consecutive court dates, leading the court to issue
Child
capious
support?
warrants and forfeit his bond. But on November 22nd, 2024, 3 days after the bond was forfeited, Mr. Dailey finally secured counsel attorney Timberly Davis. Attorney Davis took 2 key steps to try to turn the case around. First, she challenged the probable cause, and second, she sought to have the original bond reinstated, or at least have the new one reduced.
All right, good morning, Mr. Dailey. What would you like?
I've talked to Madam Prosecutor on this case, Judge, and I'm approaching on 2 things. 1, bond reinstatement, and PC on this case, Judge. She and I have already discussed it on this case, and we just both want you to hear the PC if we can, Judge.
Okay.
And then on the bond reinstatement as well, Judge.
So officers initiated a traffic stop in Harris County, Texas for a vehicle having a fictitious plate bearing the word traveler on it. During the stop, the defendant refused to provide.
Traveler? Okay.
During the stop, the defendant refused to provide ID or insurance information, stating, "I do not consent to this." Officer attempted to remove the defendant from the vehicle, and defendant actively resisted by pulling his arm away from deputies until he was detained.
Once the charges were read, defense counsel sought to reframe Mr. Dailey's behavior during the arrest as fear-driven, arguing that he acted out of anxiety rather than with an intent to interfere, and urged the court to reconsider probable cause. However, the judge was firm on his decision.
Tell me what.
So we looked at, Madam Prosecutor, the interference with duties of public servant, Your Honor. Even if my client is failing to give them that, then it is an arrestable offense. But in this situation, it is, Judge. However, in this particular situation, he didn't interfere with anything in terms of his own arrest. I can, if it was a resisting or something to that effect, I can.
You're just trying to get him out of the car.
I don't disagree.
It's classic sovereign case where got the license plate, think that traveling by right is what I think how they term it.
In this situation, Judge, and the reason I'm employing upon the court is, even from what Madam Prosecutor has seen on the video, they're pulling and tugging at his arm, which put my client in some fear. It was more than one officer. It was pretty.
But he still has a duty. If they're asking you to come out, they can lawfully do that. And there are videos, and go on YouTube, right? There are hundreds of videos where officers will literally destroy your car to get you out. When you get into a pissing match with a person who has the power of arrest, who's going to win, Mr. Dailey?
We don't disagree, Your Honor.
Right. You know what I mean? That's real life.
We don't disagree, Your Honor. I think under the circumstances of what actually happened, it was not Mr. Dailey's position to resist or to interfere. That was not. He was concerned for his safety at that point. And actually, I don't know, did you hear that on the video? Right. And so in reviewing the video, it was pretty quick, pretty brash. They didn't give him an opportunity to respond per the prosecutor. In this situation, it wasn't as if he was intentionally
Remember,
not.
this is just a mere probable cause.
Yes,
So,
Your Honor, I agree.
they ask you to come out of the car one time. Yeah, it's really, so, I think that there's enough probable cause to go forward now.
Afterward, Judge Fleischer raised concerns about the defendant's repeated missed court appearances, though the defense counsel argued these were due to Mr. Dailey's limited legal knowledge rather than a deliberate attempt to avoid the process. Attorney Davis then put her own reputation on the line to persuade the court to reinstate the bond-taking responsibility for ensuring her client complied with the proceedings, a gesture the judge received positively.
The problem is, Mr. Dailey, is that we revoke your bond. Your bond is set at 2501, and you've continually failed to appear. The case and the way that you've treated us, it shows me that you just refuse to accept authority. How are we supposed to deal with that?
Your Honor, the only reason I bring to your attention is I asked the court to take into consideration, we have a Black male works every day who, and I hate to put that on the court, but I do in this particular climate, that has never been in contact with any particular law enforcement court system. And from what I can see and what I hear out here from a lot of my Black male, and I'm sure it's common knowledge, is that because they are unfamiliar with the court system, they don't know, number one. Number two, when they do come in contact with police, and my mother is assistant chief of police. So I can understand, even when I was younger, I was taught that there are certain things that you have to do with when a police officer even stop you on a speeding ticket. What we don't know is whenever these officers come up, when you're somebody who don't have the privilege of having a police officer as a parent, or who isn't familiar and is being raised in this particular climate and seeing what they see on TV and seeing what they hear and everything that has occurred, you don't know what the proper steps are. I was trained from when I was grown up what you do. I'm not saying that what he did was right or wrong. I'm not saying that how he reacted to this particular court, it is wrong. However, I'm employing upon the court to ask the court to take into a little bit of consideration. Number one, from his perspective, all defendants, can't just say this, but I do see that, from what I've known from this particular case and now in talking to him, I do believe that there is a sense of sometimes they just don't know. So I'm asking to reinstate his PR bond. I am now on the case. What you know about me, I'm a tight attorney. I run a tight ship. So, and by which of way I believe I can reach him and getting him to court and resolving this matter, which is what I talked to the prosecutor about when you were on break. It's like, let's just resolve this. Let's take care of this.
I'll buy it.
Yes, sir.
Okay.
Thank you, Judge.
Even then, though Judge Fleischer still had quite a bit to say about Mr. Dailey's overall approach to law, the court, and his mindset as a sovereign citizen.
I'm not going to do this again, though. I promise you. I don't care whoever you have. If you flake on us again, that's 3 times. It's out. I'm not going to do it again. Do you understand, Mr. Dailey? I mean, when you come to court, good things happen. When you don't show up and you continually do it, you can't expect good things to happen. Now, do you have a Texas driver's license?
Not right now.
You're not allowed to drive.
Right.
You have a bond condition and you've signed an affidavit with me today promising you're not going to drive. I don't care how you term it. Driving, traveling, however you're going to word it, whatever you do not get into the driver's seat of an automobile, a motorcycle, anything with a combustible engine where you can get on the road unless you have approval from us. Do you understand? I don't care that you have to work. I don't care if you have to go to church. I don't care if you're going to a funeral. I don't care if you're going to wherever it may be. Do not drive. Do you understand? Heed this warning. You're not going to get another one. Okay, Timberlake, I'll reinstate the bond.
Thank you, Your Honor. And I'll talk to her. We were going to try to talk to Chief, but it's pretty busy
I
today.
think the case is only 3 months old,
Yes,
so you've got time. You can do whatever you want.
Yes, sir. Thank you, Judge.
Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court now, but you must stay in touch with her and she'll tell you when you got to come back to court. If she comes back and tells me she can't get a hold of you because you're playing games or you've gone AWOL or whatnot, or you get arrested for something else, all bets off. I'm not asking for much, man. Really. And for future reference, when you get into a pissing match with someone with the power of arrest, you are nearly always going to lose. It's just the way it works. And as a young Black man in today's society, you got to be extra special careful because things can go really wrong really quick. And there's evidence of that over and over and over. Okay? All right. Good luck, guys.
Thank you, Your Honor. Thank you, Judge.
On March 17th, 2025, charges against Mr. Dailey were dismissed after he completed a decision-making class and made a donation in exchange for a dismissal. But while Mr. Dailey's unfortunate reality check ended on a lighter note, the same cannot be said about Juan Jose Serna, the sovereign citizen whose rap sheet was so long that Judge Fleischer couldn't help but get visibly frustrated reading through it.
You are Juan Jose Serna. Yes, sir. Mr. Serna, you now stand charged yet again with burglary of a motor vehicle. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 20th, 2025, law enforcement officer was dispatched to a burglary of a motor vehicle that occurred in Old Navy parking lot in Harris County, Texas. A law enforcement officer spoke to two witnesses who viewed the incident. The first witness stated that the suspect's motor vehicle pulled up the complaining witness's motor vehicle, and the suspect wearing a camouflage hoodie got out and pulled on a door handle of the complaining witness's motor vehicle, attempting to open it. That set off the alarm of the motor vehicle, and the first witness advised that the suspect got back into a car, drove off to another area of the parking lot, parked and waited for the alarm to stop. The first witness stated that once the alarm stopped making noise, the suspect jumped back over to the complaining witness motor vehicle, parked, and the suspect in the passenger seat got out and was able to make entry into the complaining witness's motor vehicle. The complaining witness advised that she was walking up to her motor vehicle when she saw a Hispanic male wearing a camouflage jacket sitting in the driver's seat of her motor vehicle. The complaining witness stated that the suspect saw her walking up, jumped out of her motor vehicle, got into the passenger side of a waiting vehicle. The complaining witness then heard the male tell the driver, "Go, go, go." Another law enforcement officer advised he was patrolling the gold Tahoe that the suspect was observed in, passed him at a high rate of speed. Traffic stop was initiated, and the law enforcement officer was able to send pictures from the witness showing the suspect motor vehicle leaving the location to another law enforcement officer who was able to verify the suspect's motor vehicle. After further investigation and search of the suspect, camo jacket was found in the rear seat, and a flat-pointed screwdriver consistent with the tool that would be used to break a lock on the complaining witness's door.
It was both that were attempting to B&B.
Yes, Your Honor.
Because of some slightly confusing wording in the probable cause affidavit, Mr. Serna's attorney understood it to mean that only one person actually attempted to enter the victim's car, specifically the Hispanic man in the camouflage hoodie who set off the alarm the first time and was then seen inside the victim's vehicle during the second attempt. Because of this, the defense counsel's strategy was to challenge probable cause by emphasizing that when police stopped the suspect's car, Mr. Serna was not wearing that camouflage hoodie. Therefore, she argued that there was no conclusive evidence that he was the same individual that the witnesses saw committing the burglary.
The complainant or the witness stated that she saw a Hispanic male with a camouflage hoodie. When they were pulled over, there's two people in the vehicle. The camouflage hoodie was not on my client, so I'm saying that there's no probable
They
cause.
have both of them in the car, being car.
The both of them in the car.
That's what according to you, right?
Yes, Your Honor.
Both individuals.
Were in the car attempting to.
I have the
Because I thought it read that one person wearing a camouflage hoodie was in the car. with
That was the
somebody-
second one. So the first person goes in, gets out, and then that's when the other one goes in. And then at that point, the complaining witness comes up and tells them to take off.
With that clarification, probable cause was firmly established, but Judge Fleischer wasn't going to move on without giving Mr. Serna a harsh reality check. The judge walked through the defendant's extensive criminal history, and he was not hiding his frustration in the process.
Mr. Serna, let's go through your stuff. Theft of wire or cable, theft, trespass, evading arrest, burglary of a motor vehicle, theft, assault of a family member, attempted burglary of a motor vehicle, theft, third, burglary of a motor vehicle, unauthorized use of a motor vehicle, evading arrest in a motor vehicle, burglary of a motor vehicle, assault, possession of marijuana, robbery, felony theft, assault, a prior, now a felony, another felony assault, unauthorized use of a motor vehicle, tampering with a government record, felony theft, unauthorized use of a motor vehicle, and now open, you have unauthorized use of a motor vehicle, felony theft, burglary of a motor vehicle, and possession of a criminal. What on earth do we need to do to keep our county safe? It's a rhetorical question, but I don't know what on earth we need to do to ensure that our county and our cars are safe. You live in Houston, dude. You don't live in Montana or Wyoming. People like their guns and they like their cars. And when you muck with the wrong person, they're going to shoot your ass dead. It happens time ask time.
Mr. Serna's attorney attempted to persuade the court to adjust the bond and to schedule the next hearing after Mr. Serna resolved several other pending felony cases. Judge Fleischer granted those requests at the same time he delivered a series of stern warnings and unmistakable foreshadowing about the consequences Mr. Serna should expect in this case.
I don't know if you're going to get out, but if you do, I'm ordering you to have home confinement. I don't want you out at all because you scare me, Mr. Serna. You really do. You're not going to be in possession of weapons. On your other ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol. I don't want you using any dope. And let me be frank. If I find that you break any of these conditions on your bond, I'm going to make your bond so high you'll have teeth popping out. Do you understand? Let me ask you this. You ever had a job before? Like a full-time job?
Yeah.
That's probably a good idea. When you have too much time on your hands, you become self-destructive. So with this, it's just a matter of time, dude. It's either dead or 50 years, man. Really? Life's too short to live in a 6x9 box for the next 50 years.
Watch this video next if you enjoyed today's episode.